All right, we will call this meeting to order. Can we have a flag salute? Salute, pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Roll call, please.
Julie Beechner Taus.
Here.
Joe Marcano.
Here.
Mary Little.
Here.
Jose Gonzalez. Lori Eskew.
Here.
James Robinson.
Here.
Lori Cisneros.
Here.
Thank you.
And for the record, trustee Askew is by video. Can I take a moment for silence for today, please? That we've gone through so much in our nation just this last week with so many things happening. And today's just been heavy, heavy day. So I'd just like to take a moment of silence, please. Thank you. You know, we're all up here for a reason, and like so many people that have gone just recently, you know, we're here for the children. So thank you all. The meeting today is, like I said last night, for Advocates for Faith and Freedom. Ms. Fletcher called me. We had a conversation on Monday, and she explained to me that there are two cases pending that she are going to go to the Supreme Court. And one is Little versus Hecox, and the other one is West Virginia versus PBJ. And both of those cases involve a male student who has sued both states, claiming gender equality, that they want to participate in girls' sports, because both states have implemented a law saying that they're upholding Title IX, I'm sorry, Title IX. And they don't think it's fair or just. So they're suing the state. It did go to the Ninth Circuit, and they are, I think it's a stay or something, and then, so they're gonna go ahead and send it to the Supreme Court. So when they send it to the Supreme Court, which oral arguments are supposed to be next week sometime around the 13th or the 14th, they want to know if we would sign on as a signee on the case, on the lawsuit. They did contact all school districts in California and asked if we would be interested, because we have upheld the Title IX resolution. The reason that they are asking schools in California is because they were approached by a charter school in California in which this is also happening. And I don't think, I'm not sure if it's going to go to trial. I don't know the specifics on all of that. According to Ms. Fletcher, that we will not be held liable. We're not held liable in any way. We don't have any say in the case. We are just there as a signee and saying that we support this and that it's going to the Supreme Court. Becky, who is a boy, is in the West Virginia case and wants to be able to participate in cross country. So she sued West Virginia, stating that the law violated the Constitution and Title IX. So that's the one in West Virginia. And Little versus Hecox was a federal lawsuit challenging Idaho's Fairness in Women's Sports Act, a 2020 state law that banned transgender girls and women from participating in school sports designed for females. So that's the gist of everything here. They said if we sign the agreement, which I have at your seat, that I just have to assign it and send it back to them along with a statement saying that we support this. So I would like this open for discussion and see what the board thinks.
So
just to clarify, in reading the attorney engagement agreement, the agreement is to have another firm prepare an amicus brief. An amicus brief is basically a brief saying that we're, as a friend of the court, we're not a party to this action, but as a friend to the court, this is our opinion, and this is what we think should happen in the case. So in that sense, we're not a party. So just to be clear on that, that's your understanding too, right?
Correct.
Right. So and then I had some questions as to the agreement itself, because I want to make sure, even though the agreement says that we're not going to incur any costs, there is some language that does kind of confuse me in regards to that. So I just want to make sure that we're not bearing any costs. And then there's language in there as far as having to pay the costs of the other party. But it's my understanding that that should not come into play for filing an amicus brief. We shouldn't be liable for any cost of the other party. So those are a couple issues that I wanted to clear up.
Thank you. Can I interrupt this for just one moment, and then we can make a motion for the adoption of the agenda, please, which I totally forgot.
Motion?
Second.
All those in favor?
Aye.
Any opposed? So ordered. Thank you. So getting back to your issues, Joe.
There's no public comment, I'm assuming?
No, there's no public comment. I don't see one.
I didn't know.
Unless Steve wants to talk for 2 hours.
I'll spare you this time.
He only
Okay,
gets 3
thank you.
minutes.
Yeah, you only get 3 minutes. So going back to your concerns, they did assure me that we're not going to be held liable. We do have to write a statement back to them, and we can include that in our statement to make sure that they understand that we will not be held liable for anything.
And paragraph 12 is what I was concerned with. Risk of paying prevailing parties fees and costs. Client, that would be us, understands that the court may award the opposing party or parties damages, costs, and attorney's fees, and client is responsible for covering said damages. This is something that you commonly see in agreements, but I just wanted to verify that shouldn't come into play in the filing of an amicus brief. I don't see how we would be held liable for the cost of another party just by filing an amicus brief.
Well, the language under legal fees and costs in number 4, it says, therefore, firm agrees to provide its legal services without charge to client pursuant to the terms therein. So we're not a client by your definition of an amicus brief. So we're just in agreement with the client. So wouldn't that absolve us of any liability?
No, we are the client.
You're named
In the
as the
in the
client
second
at the top.
paragraph, Kern County Board of Education hereinafter referred to as client,
Okay.
so that would be us.
Well, that was an oversight on my part. My apologies.
No, it's okay. That's something for discussion. I think it's a good point. She did always tell me that it will be pro bono, so I'm,
So there's a question of our costs in preparing this and filing it, and that's covered in paragraph 4, that the firm agrees to provide its legal services without charge to client pursuant to the terms herein. So that's our cost to basically prepare and file this document. But in paragraph 12, that's paying the cost of the other party, the prevailing party, if they should succeed on their claim, we would be liable to paying their costs. So that's one thing that's my concern here, because that normally doesn't come into play for this type of filing. It's not as if we are suing the other party and the other party wins and then we have to pay their costs. Here we're merely just having a brief filed on our behalf. So that's one of my concerns. And also at the end of paragraph 4, there's a sentence that client will make a good faith effort to help firm raise money to support this case, among others. So I want to know what that entailed.
is that page 1 or 2?
That's the first page, last paragraph or last sentence of paragraph 4 on page 1.
I see it.
Ms. Offant, do you have insight on that? Is this a good time to bring her up here and?
Before we ask her, I just
Okay.
have one last question. I'm hoping that we would be entitled to review this brief before it gets filed, so that we're all in agreement on what the brief represents.
She did say that she would send it to us, and I told her that we would want to see that, and if we did not like the brief, that we could bow out of it, and she said that's acceptable.
And I assume we wouldn't be charged anything if that
That's
were the
correct.
case.
That's what she told me.
So those are my main concerns. I don't know if the rest of you have any follow-up or any other concerns.
I did ask that, so thank you for asking that.
Those were the same things that I highlighted. Pay the firm's bills on time, nonprofit, make good on the effort to help fundraise, and then, of course, the paragraph 12 to cover essentially what sounds like the cost if the other party was to prevail. My other question was, last night you referred to other districts reviewing this and joining this possibly. Do we have a report on where any other districts stood, either in Kern County or?
I did
Yeah.
not follow up today, sorry.
Okay.
I can do that tomorrow.
Is this something that we're on a strict timeline for?
It is, that's why it was a special called meeting, because they have to have oral arguments the 14th or 15th, and the brief, amicus brief will be done by the 18th, I believe.
My understanding is that the Supreme Court takes a very, very low percentage of cases that are presented to them. Now, if I understand presentation, that would be the amicus brief, right?
Well, basically, they take a low percentage of cases to review, which is called cert, and cert has been granted for these two cases, so these two cases are being reviewed by the Supreme Court. As far as the brief itself, the parties involved in these lawsuits will be briefing the matter, and then we're coming in from the back of the room, giving our 2 cents. That's our amicus brief, essentially, is as a friend of the court, this is what we think. So it would be considered, it would be reviewed by the Supreme Court.
Okay, reviewed by the Supreme Court, but does that mean that they are actually taking the case on? And if they review that, does that automatically mean that they're going to be issuing a judgment based on that review?
They're already taking the case on. They've accepted review of both of these cases.
Yeah, okay, I'm just trying to understand. I'm not one of these lawyer people, so.
And my understanding is that they're seeking out school districts who have written a resolution in support of Title IX.
Right.
So I haven't heard of any others in Kern County, but that's why they came to us, because they heard that we had this resolution. Is that correct?
That's correct,
Okay, so they're specifically asking us because of that.
right. It's basically what she said, is just, are you going to stand behind your resolution and take it to the Supreme Court and let the court say, yes, we agree with Title IX?
And if I could provide a little further.
So are we just for support?
What, Lori?
Are we just for support?
I think it would be helpful to know the precise legal issues for both of these cases, and if I could briefly read the synopsis, the background of each case. In the Little case, and that's Lindsay Hecox versus Bradley Little. Bradley Little is the governor of the state of Idaho. The background is that in that case, transgender and cisgender women athletes brought action alleging that the Idaho statute categorically banning transgender women and girls from participating in women's student athletics and subjecting all female athletes to intrusive sex verification process violated the Equal Protection Clause in Title IX. Cisgender women athletes intervened. The United States District Court for the District of Idaho granted plaintiff's motion for preliminary injunction, and then the state and interveners appealed. So basically, the transgender and cisgender women did not like this statute that essentially banned transgenders from participating in women's sports, and then also, as part of the statute, if there was a doubt as to whether a female was transgender or a biological female, they would be subjected to an examination, which they argued would be intrusive. So they were able to.
That could be a simple blood test, though.
So they were able to get a preliminary injunction granted, basically pausing or stopping that Idaho statute, and now that's going up for appeal. So that's a legal issue in that case, and now that's before the Supreme Court. Now, in BPJ by Jackson versus West Virginia State Board of Education, if I could read the synopsis in that case. A transgender female middle school student, through her mother, brought action against State Secondary School Activities Commission, state and county boards of education, and their superintendents, alleging that state law preventing transgender girls from playing on girls' athletic teams violated the Equal Protection Clause in Title IX. The United States District Court for the Southern District of West Virginia entered summary judgment in defendant's favor, and the student appealed. So basically, the state won that case, and by way of a motion for summary judgment, and now the losers are the transgender that filed the claim. They're appealing that judgment. So that is what's before the Supreme Court in that case. So those are, in a nutshell, those are the legal issues at issue. And then it appears that we're going to be, should we enter into this agreement, we have a firm that's going to research this further and file a brief on our behalf, basically giving our 2 cents of how we think the court should rule on both of these legal issues. That's my understanding of why we're here.
I get that, and I think you're absolutely right, but I guess when you say how the court would think, it kind of throws me off a little bit, because it's just a statement of fact that we agree with the Title IX.
Normally, an amicus brief has legal points and authorities. I would assume that the firm would include some persuasive legal points and authorities, not just our feelings. That's what I'm assuming. Granted, I don't know what they're going to write.
Just for clarification, I want to make sure I understand this. So, Little versus Heckox, that is the governor of Idaho standing up and saying we're looking at Title IX as the law of Idaho. All right? I mean, that's what they're saying. They agree with Title IX, and somebody's suing them because they think the Title IX is restricting them from what they want to do. Now, as far as West Virginia versus BPJ is concerned.
There's one more caveat to that, the first one,
Okay.
right? The other caveat is that they want to go further in discovering if it is a true transgender.
So,
Okay.
The-
So the legal issue is that the transgender and cisgender women are alleging that Idaho law violates the Equal Protection Clause and violates Title IX. So that's what's being alleged. And then that's how they were able to get a preliminary injunction granted. And then the governor is appealing that ruling. So I guess you could say the governor perhaps would be arguing that, no, we are in compliance with Title IX, and the other side saying you're not in compliance with Title IX, you're not in compliance with the Equal Protection Clause. So it's a legal argument.
Okay, but West Virginia, if I understand it correctly, West Virginia has already won that, and the plaintiff in that case is it wants to go ahead and appeal this to the Supreme Court. If I understand what you just said correctly.
So that's essentially what happened. It's the same type of argument, an allegation that the government violated the Equal Protection Clause and Title IX, and then the district court basically ruled in favor of the government and defeated the claim in motion for summary judgment, and then the other side is appealing that ruling. So yes, in a nutshell, the government won in that case,
Okay.
but the defendants are appealing it, now it's before the Supreme Court.
Are both states being represented? Are both states going to the Supreme Court for the same case, I guess is what?
They each have their own separate case, but it's the same legal issue, whether these laws violate Title IX, whether they violate the Equal Protection Clause.
Thank you, okay, thank you, you clarified that for me, because I
So-
was confused.
I assume our position would be that these laws do not violate Title IX, and they do not violate the Equal Protection Clause. I assume that's what our attorneys, should we enter into this agreement, I assume that's what their position is gonna be, and they're gonna
Okay, thank you,
hopefully justify why we're taking that position.
okay.
We're so glad you're here, Joe.
No kidding.
I wish I
So,
had more time for this.
Lori,
but-
do you have any comments or questions over there?
I'm just trying to hear it. It's hard to hear you guys. I just want to make sure that, I support Title IX. So I just want to make sure that we're on board with that.
Yeah, we did vote on that, so I think we're all on board on that. The thing is now, do we want to go into this agreement? Ms. Elfont, would you have any questions or
Right, but I'm
comments?
understanding what Joe's saying. He's making sense.
Yes,
And-
we're
and-
glad he's here.
Thank you,
And
Joe.
please correct me if I'm wrong, I don't want to misinterpret anything here.
Abby, come on up.
So my comments are very consistent with Mr. Marcano's in terms of the fee agreement. Just a couple of points to add on to that with respect to the cases themselves, just for awareness. Little versus, and if I'm saying it right, Hecox is a Ninth Circuit case, so Idaho is within the Ninth Circuit. So of particular importance for us here in the state of California, because California is within the Ninth Circuit. So that's just a point of awareness of why that's of particular importance to us here in California. With respect to comments on the fee agreement, Joe honed in on the same, Mr. Marcano
okay.
honed in on the same points that I did with respect to paragraph number 4. The provision of most concern to me is the last sentence, that client would make a good faith effort to help the firm raise money to support this case among others. That's a very broad statement. So what does that mean in terms of making a good faith effort to raise money to support this case? What does that mean? What are the expectations? What is the Board of Education supposed to do to help raise money for this case? And what does among others mean? What other cases are they advocating in favor of? Are you, as a Board of Education, in favor of those other cases? How broad is that? That's a very broad statement. And are you comfortable being in favor of that broad of a statement, that you are willing to commit yourself to raising funds in support of cases with that broad of a statement of, among others, that you're willing to throw your weight and your might and your interest behind doing so without any further information? So I would just direct your attention to that sentence and your comfort or discomfort regarding that, because while yes, that paragraph says this is their work on this about an amicus brief is without charge, there are strings in that paragraph. So that's my comments about
Thank you.
that paragraph for your consideration. And Mr. Marcano's observation about the prevailing fees and costs are well taken. I would counterbalance that with the observation about what an amicus brief is. You are not a party in an action when you file an amicus brief, so the court's ability to award fees and costs against an amici and a friend of the court would be very limited, because you are not a party to the action. So the ability of the court to be able to award fees and costs against a friend of the court would be very limited. So do I like that paragraph being in a fee agreement? Absolutely not. if I was negotiating a fee agreement with an individual that had that paragraph in that, I would ask them to strike that paragraph, absolutely. But as a practical matter, do I think a court can award fees and costs against an amicus? No, I don't think that they have that ability. Getting back to the fundamental nature of this and the scope of services for them to be preparing the brief, an amicus brief, and it was touched on earlier that they will be preparing a brief representing the board's interests about these Title IX matters, and that the board is in support of Title IX. I think the fundamental aspect is that the board has the opportunity to review such briefs before they are filed on behalf of the board. And the key point there is that the board has opportunity not just to review, but vote to confirm that those briefs represent the view of the board. So that would be my recommendation, is that if you move forward with this agreement and say, yeah, the board is on board with moving forward with the agreement, that you take into consideration that it would not just be an opportunity to review the briefs once they are drafted, but that you take the opportunity to have a vote to make sure that those briefs, once drafted, and I know that would be another meeting, another step, another procedural hurdle, but to make sure that the briefs are representative of the viewpoint that you want the Kern County Board of Education name associated with, because you're putting a lot of faith and credit in an organization to put something together that's representative of your viewpoint without having the opportunity to review that in advance.
That's a good point. Thank you for bringing that up.
Allowing for that, if we're going to go ahead and review and have a vote on that amicus brief, whether or not we wish to go ahead with it. At that time, could we entertain discussions? I don't know if the board would be willing to go ahead and make some sort of a donation, if you could call it that, or offer financial support.
No, I don't want to even get into that.
Okay,
That's not even an option.
check it.
So those are my observations. I'm happy to answer any questions that you may have, but those are the points that I wanted to bring to your attention, President Little.
They're good points. I appreciate your help, your insight.
Thank you. I take it we don't have anybody from this firm present to answer our questions?
No.
And what's the turnaround time that we're looking at that this needs to get done by?
Well, the oral arguments are the 14th or 15th, I think, and then so she wanted it done like this week. If, based upon the conversations we've had and the valid points that we brought up, if I talk to her and say that we're going to strike number 4 in its entirety, would the board be in acceptance of that as it is?
I wouldn't strike it in its entirety because it does have good language saying that we're not paying anything. That part of the language is good.
So what part would you like to keep?
The last sentence.
That last sentence.
Just keep,
Strike the last
What I would
sentence.
strike,
just strike the client will make a good faith effort,
yes.
Yes,
and that's the only one?
that would be my recommendation.
Okay, the
That's
firm's
the most
bills on time?
objectionable.
That number 12, we were talking about that client is responsible for covering said damages, if we
I
can
would strike that completely.
strike that.
Yes,
Yeah.
Number 12, which part? The whole thing?
the
Yeah,
whole paragraph.
number 12.
Okay. And then I'm going back to number 4, the last sentence, client also agrees and understands that attorney's fees and costs recovered by the firm from the opposing party and parties belong to the firm. But there are no costs, so I'm not sure if we need that in there. Client agrees to cooperate.
Talking on the
Number
sec-
4.
second page.
And then client also, it says client agrees to cooperate fully with firm with respect to any claim made by firm for the recovery of attorney fees and costs against the opposing parties or party.
Or wouldn't the opposing parties be the ones paying the lawyer, paying them then?
That I agree is likely superlative, but it's not something that I would really, it's not.
Nothing to stress about, okay.
Right. Because I don't think they have the opportunity to collect it, but that's not something that I would really, I don't think there's a lot of value in pushing on, because I don't think that they have the opportunity to. If they do, if they have that opportunity, more power to them, but there's no harm, no foul to us. Mr. Marcano, if you feel differently, please weigh in, but I don't.
Right, I don't think they have the authority to collect those costs from the other party.
Correct. So as I said, that's not something that would have an impact to
Could
us.
the judgment include, as part of the result of the trial, of the review rather, could the court in fact go on ahead and compel the opposing party? Well, no, then we'd be on the hook for that also too, so,
See, we're not a party.
Yeah, we're not-
Mika, aren't,
okay. All
we're
right.
friends are never, friends of the court are never parties.
I liked how you phrased that. So again, if we strike those two items, and they're agreeable, then we can enter into this.
I'm comfortable with it if we do make those edits.
I would also add, though, I would like to see the actual amicus brief.
And we
I
will.
really want to see our statement before
We'll see
Yes.
it.
we'll see it after we agree to
Yes,
go
but-
into it.
But she said we can bow out of it if we don't like the brief.
So review of a document isn't something that would normally be covered in a fee agreement, because the scope of services talks about them preparing the amicus brief document, but review, timing, signature, submittal of a document is not, the detail of that is not something you would normally see in a fee agreement. That your client arrangement with a firm is something that's your back and forth with your attorney in terms of setting your expectations that, you won't submit a document until I've had an opportunity to review it. That's attorney-client relationship aspect of things, and that's your professional responsibility obligations that, if your client says, you do not have my authority to submit a document to the court until I've had the opportunity to review and approve it, that's the attorney's professional ethical obligation to not submit something to the court until the client has approved it. The specifics of that are not something that would be covered in a fee agreement. That's the professional obligation of the attorney in the conversation. In this instance, it'd be between the board president and the attorney, for President Little to explain to the attorney that, I want the opportunity to review it, and you don't have the authority, Mr. Attorney, to submit the document to the court until I've blessed it on behalf of the Board of Education. So that's just a matter of conversation and communication between President Little and the attorney. That's
Thank
not
you, Abby,
something
for
that would
clarifying.
be specified in this document.
So you would not normally see that, like in paragraph 2 under the scope of services, it's unnecessary.
Correct.
Events at Dodger Stadium, often without any advance notice or warning. Such
I'm just going to speak freely here. I think we already did a strong due diligence with signing a resolution to Title IX. I feel like this is a very quick decision for something that's at the Supreme Court level. I feel like there is language in here that I would like to see removed before we were to move forward, and anytime there's fees, it concerns me with spending taxpayer money, and that we're really, our job is within the county, and what can we focus on that's within the county? We've made a very strong statement, again, already with the resolution. I would not be comfortable tonight approving any of this without, once again, seeing the corrected language. So those are my thoughts, Madam President.
Any other questions or comments?
So my question too is, if we decide to move forward with this, and then we want to see the verbiage on the brief itself, does that require another special meeting and in-person and a vote?
Well, like Ms., or Abby said this, she said that we could do that, and I agree with her. I think that makes sense. So it'd be up to you, you know, would you want to meet again to approve the brief? And I would say yes.
I would say yes, but we need to give the public 24 hours, we need to give opportunity for public comment and the whole 9 yards, right?
Correct.
Okay, I just want to make sure I understood that process, but if it's due by the 12th or 13th, which is,
3 days from now?
Yeah. Well, by Monday, I would, let's see.
so we would need
today's
to
the
meet
12th.
again before Friday or by Friday, this Friday?
No, because the oral arguments are, what'd she say,
I thought the oral arguments
That's
were
at
the
the 15th.
18th or something like that. Yeah, maybe we should figure that one out first.
and then she said the amicus brief would be filed by the 18th.
Oh, okay, the brief would be filed, okay. So that's the date. It needs to be signed and submitted by
Correct,
the 18th.
correct.
Oh, okay, okay. So technically, there's still time.
So there's still time.
And the 18th is next Thursday. And that's the only choice, is to be in person again. I'm just getting that in my head. Okay. I think, in my opinion, I'm just going to voice my opinion, I think it's worth it. We already took a stand on the resolution for Title IX, and this would show that we're committed and that we are not going to waver on our stand. And in my opinion, this whole issue that's happening, even in light of the events that happened today, it's a spiritual battle, in my opinion. I know not everyone shares that opinion with me. This is an attack on, in my opinion, it's an attack on God and his design. I just feel so deeply inside of me that we need to protect the females in the female sports and in the locker rooms and bathrooms and everywhere, that we need to be consistent in our stand with that. So I want to move forward with it, with those stipulations that will strike those two lines, or strike number 12 completely, and then the one sentence in number 4. And I'm willing to come back down the hill to do another meeting and to sign it. So that's where I stand.
Well, these, Idaho and West Virginia respectively, there's a very good chance, we're in California, that at some point in time, we might need the support of other districts, possibly other states, if we run across a bone of contention that sticks in somebody's throat up in Sacramento that we're fighting for. And if they were able to, if other people were able to go ahead and support us the way that we, right now, or that I'm in favor of supporting these two states with this, then I think that we would be, we'd be registering some good faith. And not to mention, I agree with Lori 100%. This has come down to a spiritual battle. We may as well go ahead and look at it that way. At least that's the way I'm going to go ahead and look at it. So I say that as long as the stipulations that we've made here with regards to language being removed, I'm in favor of coming in for another meeting to go ahead and vote on that.
Just so you guys know, I'm looking through the minutes here on this would be the Little case, and there's been about 15 briefs, amicus briefs filed. Granted, most of them were filed last year. So yeah, there's going to be briefs from, I assume, from both sides being filed on this. I'm all for entering into this battle and filing one that's accurate to our beliefs. And I am okay with approving this agreement as edited, and then we could come back again after we actually have a copy of our brief.
Okay. Thank you for all your comments. For my comments, I think this is a historical landmark that shows that schools are important and in supporting what's right for girls' sports. The more that we make our voices known and heard, and other people are going to say, yes, they did that. They made their voice known and heard. I'm going to join them. So it's a stepping out of this I don't think has ever been done before that I know of. And I'm pretty honored to be able to have this opportunity to say Kern County Board of Education supports girls in sports and boys in sports and the original intent of Title IX. So I'm in favor of it, and I understand the legal aspects of taking out those two items. And if I talk to her tomorrow and she agrees, I can have a new agreement sent to you tomorrow.
I don't see any briefs from a Board of Education on here, but there's briefs from different, there's organizations, there's Alabama, there's representatives from Idaho, and all sorts of other entities, but yeah, we would probably be the first Board of Education.
That's pretty awesome.
Do we know the content of the respective briefs of the other organizations that have filed, or was that like too cumbersome to get into?
There is a link for each one, but yeah, you'd have to click on each of these 15 links and read them.
I'm so glad you're a lawyer, Joe.
There's a brief from a doctor, there's all kinds of people here. Yeah, I found this on the supremecourt.gov. There's a couple doctors in here.
You need assistance.
Forward that link to the board
That's a great idea.
for our own investigation, just to read. I'd like to read some of them.
Yeah, well, you'd have to send it to.
Yeah, you'd have to send it to Merrill.
Yeah. If you can get back to us by 7, Joe, that'd be great.
Well, based upon all the comments here, Lori, do you have anything else? Lori, Trustee Askew?
You know, I just agree with Lori and Jim, and I just think this is a historical event. I want to protect girls and boys. You know, this is we need to stand by everybody that we need to stand by. We might, like Jim said, we might need them someday to stand by us. California needs to take a stand. And I'm just proud that we might be doing this.
Yeah, it's quite significant. It really is.
You know, we had a lot going on today, you know, with the assassination of Charlie Kirk today. And, you know, I agree that this is a spiritual battle, and we need to take a stance that boys need to be in boys sports and girls need to be in girls sports. God designed boys as boys and girls as girls.
Thank you, Trustee Askew. Anybody want to make a motion?
I move that we, with the proposed edits, that we go ahead and move forward and get a copy of the amicus brief for later review.
I second.
All those in favor?
Aye.
Any discussion? Any opposed? So ordered. Thank you.
Thank you.
And I will let you know tomorrow. Merle will send a email of whether they agree to our stipulations or not. And if they do, you'll see the new language or the ones that are taken out. So I thank you very much.
We adjourned.
We are adjourned.
Have fun with baseball, Lori.
Thank you,
All right,
Lori.
thanks. Go Dodgers.
Go Dodgers.